Okay, I'm trying to set this up so we can.
Okay, here we go. We are broadcasting now. Welcome, everybody, and thank you for joining now the continuation of our collaborative event organized by the Armenian Bar Association and the Armenian American Medical Society. As you all know, we have been organizing these educational sessions to address various aspects of this global pandemic that we have found ourselves in, and all the challenges, whether it be healthcare related, whether it be logistical related to professional practice, or employment or business taxation aspects of this COVID-19 era as it pertains to medical and professional practice. We are truly thankful to have a very able and collaborative sibling organization in the Armenian Bar Association under the leadership of a good friend and colleague, Mr. Gerard Kassabian. Dr. Kassabian, I'd like to thank you and the rest of the board for really working diligently to bring these educational sessions to our members and other members of the professional world. Gerard, I'd like to welcome you now to say some opening words. We have a very interesting session today with two speakers, Mr. Kassabian being one of them, who is, as many of you know, is an estate planning attorney, and Mr. Vic Abajian, who is a tax attorney. However, I'd like to invite Gerard now to take over and give us some introductory remarks.
Thank you, Dr. Sapilian. It's a pleasure, as always, to be on with the Armenian Medical Society, as we call it, the Armenian American Medical Society. We are in partnership for the third Zoom conference together, and thanks to them, we started doing these Zoom conferences. And in the background, Hasmik Keiribarian is helping, and we always appreciate her assistance. We are here today representing the Armenian Bar Association. I'm the chairman, Gerard Kassabian, and we are an international organization of judges, lawyers, professors, students, and pre-law students who come together to share information and to share their thoughts and things that they've learned, experiences, not only in the United States, but in Canada, in Europe, in the Middle East, and especially in Armenia and Artsakh. We have board members serving from Canada and currently predominantly with the United States, but we welcome members from all over the world. Tonight's program specifically focuses on tax and estate planning issues that have arisen as a result of the COVID-19 pandemic. And one of our presenters today is my good friend and schoolmate, Vic Abajian. Vic worked at the IRS after graduating Southwestern Law School. Actually, he did an LL.M and graduated with honors from Georgetown University, the law school program, the Master of Laws in Taxation program, to be specific. After Georgetown, he worked at the IRS, technically for the Department of Treasury, representing the IRS in the court system, on the opposite side of the fence, basically representing the government for all kinds of taxation issues. And now he represents taxpayers, defending them with the same kind of attacks that he used to bring on. Vic is a good friend of the Armenian Bar Association, a longtime member and supporter, and we appreciate the time and effort that you've put into being here today, Vic. Due to some technical issues, I'm going to be going first on our presentations. Welcome, Vic. Thank you. Without going on further with bios, I'll let Vic introduce himself a little bit more when he comes on, but I'll start my presentation so that we can be on time. Let me share my screen right now with the PowerPoint presentation. 1 second. Okay. So COVID-19 has brought some interesting changes to our profession. Is the screen's not showing right now, but excuse me 1 second while I redo this. Okay, for some reason, screen number 2 is showing up as black. Let me escape out of this. I'll talk through it instead of dealing with that.
It may be the animation. There's a slide transition animation, so you may have to give it a few seconds and it will turn.
Okay.
I can do it too if you need to, Gerard. Let me know.
Okay, no problem. Let me just talk through that while I'll go through and take all the animations out of this. It was a simple, I can do that in 1 second. So, all right, done. Sorry for this technical glitch. We are learning as we go. I am learning, the rest are professionals. Okay, perfect. Thank you for that. That was a great tip to know in the future. No transitions in your PowerPoint slides. So, COVID-19 started. Everybody was told to stay home and social distance, but at the same time, everybody's worried about their health and what happens if they become incapacitated or family members who pass away. What are we going to do? So I start getting calls. I got more calls for estate planning during this short period of time than I did for the entire year prior. So I couldn't stop working during this time. And of course, you all know what we had to do if we're having. First, we were told to avoid in-person meetings at all costs, but honestly, after listening to all the specifics, I was having in-person meetings with social distancing, with masks. I made house calls instead of having them come to my office while my office was closed, actually. Everybody was working from home. Even when doing that, you can imagine the types of things we were doing. We were staying away from each other. Documents that were being presented were being laid out on a table, and while others would approach, sign, and then I would approach the same document and sign. And then they were talking about transmission of the virus through things. So it just became more and more tedious wearing gloves and doing documents. So I now am very appreciative of the work that our medical brothers and sisters do, wearing masks and gloves all day, because it was not an easy thing to do. The in-person meetings we still do, and we require masks in our offices, and we do social distance, but we do get the job done while following all of these rules. Now, the more difficult part of some of these is remote meetings for estate planning purposes. So, you know, the effectiveness varies on the remote meetings. You know that not only are there internet quality issues right now in my neighborhood, I want to join a conference, for example, and sometimes it slows down, and especially during the daytime when the children were on their school programs, it really affected our ability to get onto conferences and whatnot. Security was also an issue. We're discussing a lot of things, and we're sharing a lot of information over the internet, and some people just don't like doing that. They don't even like giving me social security numbers either by telephone or email or anything. So they want to do it all in person. So that's some of the downfalls of remote meetings. Having a lot of documents, it becomes cumbersome and tedious to go through documents with the other party on the remote meeting. And some people just are low tech and they just don't do remote meetings. So that became another obstacle. Another thing, when we have the planning part is one, then execution of documents is another issue that comes up with with these COVID-related questions. How do you execute documents? Are you allowed to execute remotely? Well, I'm a notary public, and I looked up the rules if we can do a remote notary in California, and it's not allowed here in California. Other states, such as Florida, have allowed remote notary. So the notary rules are whether the person signs or not in front of you, that's not the requirement. It's about the person who signed it acknowledges that they signed in front of you, and you must be present and have their signature and also a fingerprint if need be in your notary book. So to achieve these, there's no way we can have this done remotely. We had to have it in person. And also, of course, a lot of the documents that we sign, we need the originals for a will, for a trust, for all kinds of documents. Yes, you can use a copy of a will or a trust, but it just makes the process more difficult when trying to prove the authenticity of the document. These slides, by the way, are going to be shared. So I'll be going through them quickly, and there's many other slides in here that I will not be reviewing that are in that I've included just for your information. And I welcome you to take a look, and if you have any questions, to ask questions after both of our presentations today. And we'll have an approximately 30-minute question and answer session after we're done. So if you have any questions while I'm discussing, or while Vic Abajian will be discussing tax matters, we welcome you to post your questions either on the Zoom platform, the chat, or on Facebook, where we are sharing these the live broadcast. Moving on, I wanted to create, instead of doing a lesson about estate planning, I wanted to give you a real life example of what would happen if somebody was infected with the COVID-19 virus and they're in quarantine, and what they would ask from me as an estate planning attorney during this time. So the first scenario would be that they're infected, they're quarantined, but they're okay. They're able to, they have legal capacity, so they're able to, they know who are their family members, they know what are their assets, and they're able to enter into transactions which will be held up in a court of law. So those with legal capacity, if they have already a valid estate plan, what I would have done in that scenario is I would quickly review the plan and make any amendments if needed. That's an easy one. If they don't have an estate plan, now it becomes a little bit more difficult situation where we need to rush to prepare a new estate plan for them and execute documents, you know, and of course using preventative precautions to make sure we don't get the transmission of the virus. Now, when I talk about the difference between with and without an estate plan, the whole reason we're talking about this is so we can avoid having to go through the court systems for things that we can do by a simple execution of a document. And I'll go through each of those documents and what they do in the next few slides. Now, the more difficult scenario is when somebody has the virus and, for example, they're intubated and under an induced coma. So they don't have legal capacity. They do not have legal capacity. Now, the family members would contact me and say, you know, our family members in the ICU, they've put him under a coma, and he has an estate plan. So we would quickly review the plan and we would notify the agents in the power of attorney and also the successor trustees of the trust that since this gentleman is incapacitated, they are now holding the power to act on his behalf and may act if need be. So the three things that work in this scenario, which I'll go over in the next plan. One is the durable power of attorney, which is for financial transactions for the most part, that the agent named in there, if it's a springing power, meaning it comes into effect when somebody is incapacitated, they would be able to act on behalf of the person who's in the ICU, the patient. Second, the healthcare directive. If the patient's in a coma, they would have assigned an agent to make medical decisions on their behalf, and they would also have medical decisions that they've already made, whether or not they're going to donate organs, whether or not they want to be resuscitated, whether or not they want to be on a life support if they're deemed to be in an irreversible vegetative state. For example, those are some of the things that they can choose prior, and nobody can reverse those decisions because it's their decision and not for anybody else to make, since it's already been done in the healthcare directive, which is also known as an advanced healthcare directive and, power of attorney for health. The more difficult part becomes the person who is incapacitated but does not have an estate plan. Now, if anybody needs to make any kind of decision on behalf of the patient, first they would have to go to court and get an emergency conservatorship. Putting aside the costs, these things take time to prepare and to go to court and to get it done in an emergency fashion. Usually courts do not like to take people's rights away, and they're very cautious about doing that. And this kind of a procedure requires requires the filing of a petition, and many people are involved in this. A physician has to certify that the person is incapacitated, and that's a very detailed document that the court requires the physician to prepare. And also, the court assigns an attorney to the patient whose rights will be taken away in a limited format or in a complete format. So the attorney would make sure that the patient's rights are being protected, whatever the scenario may be. And finally, a social worker from the County of Los Angeles would be sent to ensure that all the information that's being produced is actually is verified by them. So someone without legal capacity and without an estate plan, nobody would be able to act on their behalf except via court order. And the court order, they would require you to get some type of a conservatorship in order to act on behalf of the adult. The conservatorship is the same as a guardianship, but for adults. Finally, if the patient dies in the ICU, for example, because of COVID-19 complications, without the proper estate plan, they would have to go through probate administration in order for anybody to be able to change title or access any of the funds or transfer assets out of the decedent's name into the legal heirs, the people who would be inheriting. If they did have an estate plan, then you would avoid this entire probate administration and just follow the instructions in the trust. Let me back up real quick. Again, for those who are in the ICU, they're alive but incapacitated. If they have an estate plan, meaning they have a power of attorney, they have a healthcare directive, and they have their assets in trust, then we don't need to go to court. We would have everything handled through the people that they've already chosen to act on their behalf. Let me skip to the next page. So the goal of the estate planning is to avoid going through the probate courts. Of course, the other main goal is to make sure that your wishes are put down in paper and that we being your family members would follow through with your wishes. But we want to make sure that you avoid going through that court process. It's very lengthy, it's very costly, and during the COVID-19 pandemic, when it first started, the courts were closed, so we were unable to file these emergency motions. The courts have just opened. Everything is very backlogged. All of our hearings have been pushed back by at least 2 months. So it's really a difficult time right now to get things done. So in the basic estate plan, we deal with 2 scenarios, which I already went through right now, but I want to go through it again. Incapacity, you're alive, but legally unable to make decisions or manage your affairs. And number 2, which is on the next screen, is death. These are the 2 main issues we focus on. And when estate planners plan, we plan as if these bad things will happen to you right now. So we need to plan that way in order for you to understand that if you were to become incapacitated right now, you would have to have a conservatorship over you if you don't have any kind of power of attorney documents. And in order to avoid the conservatorship, which again is costly, when I say costly, I'm talking $15,000, $20,000 just to get the process going. And then it's an ongoing process where you have to prepare documents. The court wants status updates at least on an annual basis. So you can fathom what the costs would be on that. It's like an ongoing lawsuit on a small scale. You can avoid all of these with a basic estate plan with the power of attorney for, again, for finances, the durable power of attorney, the power of attorney for healthcare, and a trust that manages assets. These 3 documents work while you're alive. So if you're alive and incapacitated, the successor trustee of the trust steps into your shoes and handles matters. If you're married and your spouse is one of the acting trustees, then your spouse is 100% in control. If you're single and you've put a brother, sister, or parent, somebody that you trust, then that person who's the successor trustee will step into your shoes. The power of attorney will cover things that are not covered that are not titled in the name of the trust. So let's say you're in escrow to buy a home, or you're refinancing a home. All of a sudden you're in an ICU and they need to close the transaction. Whoever holds the power of whoever is the agent named in the power of attorney will be able to act on your behalf for that transaction. And lastly, for the healthcare directive, I talked about that. I don't want to keep saying it over and over, but this next is the death scenario. So after death, if there is no estate plan, you are required to go through probate administration if you have any assets that need to be transferred from the decedent's name into their legal heirs. When I say legal heirs, those are people that are legally entitled to inherit after somebody passes away based on the probate code. And that usually follows the family tree. If you had signed only a will and not a trust, you still have to go through probate administration, but at least you would have named the people you want acting on your behalf as an executor or executrix. And also you would have named the beneficiaries you wanted in that. Some people have written holographic wills. Those are completely handwritten wills, and they have certain requirements by the probate code that need to be met in order for it to be deemed a holographic will. Again, just a will by itself does not avoid probate, which is the whole point of doing an estate plan. To avoid probate after death, a revocable trust or an irrevocable trust is what's necessary. The revocable trust, also known as living trust, also known as a family trust, is what usually is the standard estate plan for a family or a single person. This standard estate plan is necessary for anybody. Most people will say, you know what? I don't have an estate, so what am I planning? That's not correct. You don't have to have a mansion and 500 apartment buildings in order to have an estate plan. An estate plan means how you are planning in case of incapacity or death, and who do you want acting on your behalf during these scenarios. And even if you have just $1 in your bank account, you still have an estate. Also, some things that you don't think about that are part of your estate are, you have a Facebook account, you have an iCloud account with a bunch of photos, you have a trademark, you've written a book, or you've drawn some type of something that has a copyright. These intangible things are also assets of your estate that can be transferred through these mediums, through the trust. It can also be transferred through probate, but probate takes about at least a year, and it requires other people to get involved. And the fees are very expensive, which is on slide number 10 in the end of my presentation that I will not go through, but I'll let you take a look at some of the examples of the fees for an estate plan, for a probate estate. Lastly, there is another way to avoid probate. The first is assets that go through a trust. Second is when you have a beneficiary designation, such as life insurance or bank accounts that have a transfer on death or pay on death or annuities. All of these things avoid probate. Same with the joint tenancy. That is for real property, or sometimes they have that in other assets where if two people are joint tenants, it's a survivorship clause, meaning the survivor of them remains the 100% owner. So in these three scenarios, because it's written and it's clear that who will be receiving this asset, the court does not get involved in these three scenarios to do the transfer. In a joint tenancy scenario, it's a recorded title usually, and we file an affidavit death of joint tenant. It's clear who's getting it. The court doesn't get involved. The transfer happens outside of court. Same with the beneficiary, life insurance policy. The beneficiary is your child or your parent or your sibling. It's clear who it is. The transfer happens without having to go to court. Same with a bank account with a transfer on death or pay on death. Same idea as the life insurance. I wanted to just go over real quick what the current estate and gift tax limits are for the year 2020. You have to remember that US citizens are given preference for estate and gift tax rules. US citizens are allowed $11.58 million of exclusion per person for estate or lifetime gift or GST taxes. This is unified. That means if I gave a gift of $10 million today, I would have used up 10 million of that $11.5 million. And at death, I would have only the 1.58 million, and the 10 of it would have been used already. Annually, you can give now $15,000 instead of $14,000 per person. So if you are a married couple, that would be $30,000 per person coming from the married couple, to each child, to each relative, whatever it may be. The federal estate tax rate is at 40%. That's the maximum amount. That hasn't changed much in the past couple of years. And recently, they've allowed that a spouse may carry over the unused exemption amount. So if one spouse dies and they did not use their entire 11.58 million exemption amount, that could be carried over to the surviving spouse. That's called portability of the exemption amount. Some of the old trusts that we have out there that were signed, even today, some of the trusts require that the trust be split into two when one spouse dies. Well, we have to be very sure that it allows for a portability, and also it allows for the spouse to what they call decanting, to decant the trust that is designed to, that's called the decedent's trust. It splits up into two. That part is locked and it's outside of the estate of the surviving spouse. We want to make sure the surviving spouse has the option to put put her hand into the jar, so to speak, and decant that jar with the assets so that she can use her lifetime exemption and use those assets during her time, and ultimately use what's called a step up in cost basis. We can get into that on another discussion, but keep in mind another thing. US citizens, we have all these good benefits. Non-US citizens and non-domiciliary people who live abroad, who own property here in the US. So our citizen from Armenia who owns a house in the US, if they pass away, $60,000 is the exclusion amount. The rest will be taxed at 40%. There is no marital deduction, so any transfer between spouses is also taxed as if they're making a gift to another individual. And also, if they were to create a trust here, the non-US citizen would be required to elect a US citizen as a trustee to create what's called a qualified domestic trust, with the idea being that if the non-US spouse is alive and their other spouse passes away, they don't want the non-US spouse to gather everything and leave the country without paying any taxes if there are any. That's why they insist that if a non-US spouse was to survive, then the trustee must be a US citizen along with that non-US spouse, so that at least they can have somebody who's responsible to pay that tax be on the hook for that. My next slides are the slides that I mentioned about the reasons why you should plan your estate. You can read through this on your own. It's pretty self-explanatory, but what I wanted to just impress upon everybody, whether you do your estate plan with me or somebody else, so this is what I tell all my clients, I don't care, just get it done, because you must have just a standard estate plan, which includes a will for each person, or a family trust or a revocable trust. It includes a power of attorney for finances. It includes an advanced healthcare directive and some other documents. If you have minor children, it would have a guardianship agreement, so you choose who are the guardians. So we don't have to run to court and choose guardians on their behalf and spend all kinds of money. That's basically it. Get your estate plans done now. You don't know what the future holds, and do it while you're able. So I wanted to stop my presentation right here and thank everyone for listening. And Vic, I would welcome Vic Abajian now to give us his presentation on the income tax side of the taxation world. Thank you, Vic.
Thanks, Gerard. Appreciate it. I think, can you hear me okay, Gerard?
Yes.
Okay, perfect. Yeah, I think COVID has forced a lot of people to think about their own mortality, which I know was not fun, and ask basic questions. So I can imagine your phone was ringing off the hook. I just wanted to touch briefly on some of the Gerard covered the estate and gift tax implications. I'm more focused on the income tax implications and, just contending with the IRS, your tax returns, both corporate and individual 1040s. So we can skip to the next slide in the deck here. As the slide said, I'm here in Glendale, tax attorney. I've been almost 20 years now. We just help people with very difficult situations with the IRS. Having been a former IRS attorney and having some technical background has been very helpful. So we know the ground level people very well, and we could jump to the next slide. So one of the most important things is, getting that income tax return filed. Even though you're dealing with a lot of stuff right now, income taxes are still due. The IRS is still there. They expect their returns. What they did this year is they automatically extended the time to file from April 15th of the year to July 15th, which is coming up in about 2 weeks. And that deadline does fall in the middle of the week. So there'll be no special 1 or 2 day extension as if when it falls on the weekend. So the return needs to go in by July 15th. That extension is automatic. You don't have to apply for it. You don't have to send in a request. You don't have to be affected by COVID. You don't have to have been sick. It just applies to everybody in the group, anyone filing a return. And if you get to July 15th and need more time, that's not an issue. You can file a traditional extension to file. That'll get you out to an October 15th due date. There was talk yesterday, the IRS announced that they're not going to give an automatic extension from July to later in the year. So the due date is July 15th. Make sure you get that extension in or get that return filed. One thing to keep in mind with extensions, extension of time to file is not an extension of time to pay. So if you file a return and are self-reporting tax due, and you show a tax liability on that 1040, it's due on that day whether you extend or not. And this time it's been extended from April to July. So that's given a little more time to pay. But if you go beyond July, the failure to timely pay penalties will start running on July 16th. They do add up fairly quickly, so it's a good idea to try to make arrangements for payment. Now, a lot of times people will file returns and just can't make payment. This year, I imagine we're going to see that quite a bit. We deal with clients all the time who do that. A lot of people don't know. I mean, you could file a return. It goes to the IRS. It gets processed. The liability is assessed. It ends up on your transcript, your permanent record over there. And then they don't see a check payment or online payment, and that liability just sits open. What happens then is the IRS computer will start to send you automated collection notices asking for the liability, wanting to know where their payment's at. And so you do have some options there. What you can do is nothing will happen. I mean, if you don't send in payment, if you can't send in the payment, great. If you can't, you can set up installment agreements. You could set up an offer and compromise where you don't pay because your income has been cut drastically. So I have a feeling this year the IRS is going to be a little more flexible on installment agreements. It's something very common that we negotiate all the time. We're basically telling the IRS, look, we can't make a lump sum payment right now. We've got cash flow problems. We've got payroll we've got to cover. We've got a lot of issues. Our medical practice is down by 80%, by 50%, and it's slowly coming back. We will be able to pay you. So that's something that can be arranged. So if payment can't be sent in, that's something you can work with. One thing to consider if that happens is a lien. The IRS could eventually file a notice of federal tax lien, which is going to impact your credit, have a negative impact on your credit score. If you've got lines of credits, if you've got vendors looking at your credit reports, this could be an issue. So again, you can be proactive here, reach out to the IRS and say, look, I've got a liability. I'd like it assigned to a revenue officer in the field to review the lien filing and arrange payments. And we could basically put these things on ice for quite a while. So you do have some options. And they also did some extensions for the quarterly payments. Those are not due until July 15th. Also, so the first and second quarter of this year estimate can be made by July 15th. And that's going to help. Again, there are basically a lot of provisions that have been passed that are allowing deferral, more time to pay the tax, and so on. These come under the CARES Act. And by the way, the CARES Act put in quite a few significant tax provisions in there. You can now carry back net operating losses from the, I think, 18, 19, 20 years for the 5-year prior period, get refunds if you pay tax. If you're in a business where you've taken out loans or you've contributed personal money this year to keep things afloat, you might end up with a loss at the end of the year, and those can be carried back. And if you were profitable in the prior years, you can get that tax money back. There's other provisions like now you can get penalty-free access to your IRA. So that's providing another source of funding, and there are limitations on the amounts, and you've got to pay it back in certain time. They've expanded ability to take certain deductions. There's employer tax credits. There's really just a slew of provisions out there to help defer tax, less limitations on losses, and more credits. And so if we go to the next slide, is the IRS still operational? Basically it is, although it's kind of limping along. The IRS is trying, each function has been a little different internally. So They are trying to go with electronic formats. I know some of the service centers in Fresno and Austin and in Ogden and Philadelphia had temporarily closed or were not accepting filings anymore. Stuff we were sending in was not getting filed. Checks weren't getting cashed. And certain filings we were doing had to be done paper. So we kind of saw that happening. They've got a lot of online stuff, though. IRS.gov is a very good source. Their website's very good for online options. You can make payments through their website. And they've pretty much said, they've kind of laid out, you know, we're having significant delays in paper filing, so go ahead and try to electronically file. We are accepting paper filings, but those are going to be processed on a first come, first served basis. If you provided a, you know, paper file, don't try to go in and do an electronic filing. That's just going to slow things down. And correspondence been the same way. If you've got to correspond with the IRS for whatever reason, doing it in writing, it's just going to take time. Again, it's going to just be quite a while for a physical person to get back to you. IRS was never really set up for work from home. Not most employees were not. They don't have the ability to mail from their house. IRS very rarely uses email. They don't like to send secure data over email. They just got eFax. I think it's been about 2 years now. So they're kind of behind on that point. If you've got notices coming in from them, there are certain extensions of time being given, and those are usually extended out to July 15th also for payment options or certain collection notices or other rights that you may have. So, and we can go to the next slide in the deck. And the next one's basically talking about other IRS. Is the IRS operational? Next is other IRS operations. So what we have here is the various functions. Of course, auditors are still there. Again, they're working from home. Their managers are trying to check into the offices once in a while, pick up mail. They've been kind of limping along. So they're kind of commuting by eFax. Everything's been by phone. Now this has been useful. We did get a criminal subpoena for a client just before this took place. And I basically called the special agent, said, hey, look, I've got an underlying health condition. I'm not going to see anyone face to face. And by the way, my clients are elderly, so they qualify also. Why don't you send me your questions in writing? And the agent said, well, we'll come back to you. And, you know, they never sent us anything in writing, of course. We're on hold. Hopefully they go away. We're just going to wait and see what happens. But I don't think they're going to be able to interview my clients under any basis. And I don't know if I can do a Zoom interview because we all can't be in the same room. And that's kind of important for several reasons. So we'll see how that plays out. The statute of limitations on audit cases is running. So the IRS is focused on asking you for more time. You don't have to sign an extension for time. If you're in that position, we've been using that to our advantage and saying, look, go ahead and close the audit, send me a report. I can't sign a statute extension right now, sorry. So we'll see how that plays out. There'll probably be some cases that'll fall through the cracks and some taxpayers will get away with the expiration of the statute. So IRS generally has 3 years to audit. Once you're under audit, they always run slow and they ask for more time. Office of Chief Counselor, the attorneys, that's where I used to work. They represent the IRS in front of the tax court. Tax court has basically delayed all calendars out until later this year, and those are starting up and status reports are being requested. So again, everything's just kind of on hold. Office of Appeals is in the same boat. They're working from home. They're not set up, and that's made it quite difficult to kind of get documentation back and forth. And then we can go into the next slide deck. IRS collection efforts. Again, I touched on this briefly earlier. On this slide, there are situations that we're running into. You might be in escrow right now and have a small lien from the past that's clouding title and making it difficult to sell. The buyer is obviously not going to want to close escrow until that you get a lien discharge with the IRS. That group is up and running, and they do have, and they've presented electronic options. So we're still able to clear those. I think we got one just approved recently. And so that's something we're seeing quite a bit. And then last but not least, popular topic's been the PPP. I know a lot of folks here have probably gotten a PPP or know someone who's gotten one. Essentially, it's a loan that's supposed to be forgiven. Of course, the deadline was today, June 30th, to put in an application through a bank to get that type of funding. I know there's been speeches here and talks on that topic. It ended with about 134 billion or of funds that were not handed out. So one question we had right off the bat was, okay, if that loan is forgiven, does that constitute income to you? Because generally the tax law is set up that if you have forgiveness of debt, you're that much richer and therefore it's considered income. So the IRS just recently issued Notice 2020-32 to address the deductibility of loan amounts received under the Paycheck Protection Program. And so what they've come out and said, well, okay, it's not income and you don't have to pick it up at income, but any amount that's forgiven under the program and qualified payments that you used of your PPP funds that were forgiven are not deductible. So most of that money is supposed to go to payroll, of course. And if you make that payroll, there's not going to, you're not going to get an income tax deduction for that. The problem there then becomes if you are in, and this was kind of a shocker, I think that was not the intent of the CARES Act. That was not the intent of Congress. So this is fluid, like many things with COVID. They're still working on what to do, how they're going to address this. We think this is going to change, but currently as it stands, although it's not income to you, you don't get a deduction. So if you're a typical medical practice, you're probably mostly service-based. You don't have a big cost of goods sold. Although income may be down this year, you're probably going to be at a net profit at the end of the year. This amount will effectively be subject to tax. So your benefit won't be 100% of the PPP amount. So that's something to keep tabs on. I have a feeling that's probably going to change, but we'll see. And what else can I say? Yeah, the other thing is usually when you have loan forgiveness and you apply for an exclusion to income and say, look, my loan was forgiven, but I'm insolvent at the time of forgiveness, so don't count it as income. The IRS will accept that, but then you have to reduce other favorable tax attributes. Like if you have a loss carrying forward from prior years, now you have to reduce that loss. And so that hasn't been addressed either under the CARES Act. We're waiting to see what's going on. So again, many in the Senate and Congress are kind of shocked at the IRS notice. Maybe they got it out a little quick. We'll kind of see what the next steps are. And that's basically what I've got today, kind of a brief overview.
Great, thank you, Vic.
Thank you, Vic, for that very, very informative overview of what's going on from a taxation. And Gerard, really, that's very sound advice for, all of us who are could heed that advice and benefit from that. At this point, like Gerard said, we are open for a Q&A session. You may put your questions in the chat section as well as the Q&A part. And if you are watching on Facebook, also please put that in place your comments or questions in the comments section, and we're monitoring those and we will get to those. I also would like to remind everybody that as Gerard mentioned, the slides and a video of this presentation will be available on the website of Armenian American Medical Society, AAMSC.org. If you browse the webinars by date, you'll be able to see a video of this, a recording of this, and also the slides. We do have a question in the Q&A section, and this is a specific question coming from one of our dental health professionals, and the question goes: is the $15,000 annual gift tax exclusion exempt from the cumulative lifetime gift of the 11,580,000? In other words, if both parents are paying $15K each year to their sole child, totaling $30K annually, let's say over the course of 20 years, does that mean that upon the demise of both parents, the child's exemptions kick in after 12.1 million? I believe you answered this question, Mr. Kassabian, but I will also give you the opportunity to answer it again during the Q&A.
It's a great question. The $15,000 is an annual exclusion, and it's not cumulative. If you either use it or you don't, and you have the ability to use it every year. It is not. What happens is if you make a $100,000 gift, the first $15,000 of that is not taxed. The rest of it will be calculated. That's how they calculate it. So if you make a $15,000 gift to your child, and then you make another dollar gift during the same year, that extra dollar will be taxable. And the $15,000 that was exempt will be used up in 2020, and next year it gets reset and you get a new $15,000. There's no cumulative effect on that. Another question on the Q&A was, if I were to receive a $15,000 gift contribution, would I claim this as income as well and pay income tax on it? So when whoever receives the gift does not pay income tax or gift tax. The one who makes the gift pays the gift tax if it's above $15,000, and of course they can use the exemption to get away from the tax. So that's another great question that was asked earlier. And the same person asked another question about an IRA, which we can get into later if we want to. But I, you know what? Since I mentioned it, let me just say it. It says, I'm 60 years old. I'm planning to withdraw an entire amount from my traditional IRA. Do I need to report this as income on my income tax or not? I've heard contradicting info. What's the correct guideline? Thank you. So my understanding is that you can withdraw as much as you want after age 59 and a half without the 10% penalty. This is new. But yes, it will be deemed income because the money in there is pre-income money, pre-income tax money. And so they're going to have to tax you at some point. In tax classes, we always learn that the answer to the question is it taxable? Is always yes. Then we have to find a way of getting away from it. Right, Vic?
That sounds accurate.
So let's see. Any other questions that we can...
So there is a question that has come through, which is actually, something that may be very relevant to both organizations that are organizing this session, and that is regarding any of the relief loans as it pertains to nonprofit organizations. If you can, Mr. Abajian, if you can elaborate on if a nonprofit organization or a nonprofit corporation received any of the PPP or other relief funds. Are there any differences in the way that the forgiveness parameters are impacted?
I'm not sure. I know the EIDL loans that were being given out, I think nonprofits qualified initially, if I remember reading correctly. We never helped a client go through that, a nonprofit, so I'm not really sure. But I remember them being specifically mentioned, I think, is able to get a loan. And then at some point, there was such a demand, they closed it, except to agricultural businesses. And I think that restriction was lifted recently again. So I think they could apply. As far as how and I do remember filling out now one of the applications for an EIDL. And I believe there's specific mention of a nonprofit. So the issue will be, like you said, what expenses can you, would be covered expenses under the CARES Act for forgiveness later. I guess a nonprofit still has payroll. A lot of the nonprofits we work with, they have rent. So they kind of operate like a business. So I would imagine it's somewhere along the same guidelines, but I'd have to take a look into it. I'm not sure.
Great. Yeah, thank you. We have a question to Mr. Kassabian. It's an anonymous question, and first the person who's asking the question says, "Thank you for all the great information and presentation," and goes on to say, "What is your backlog or lead time that is necessary to get an appointment?" And also a second part of the question is, what is a ballpark estimate financially on getting the process of estate planning rolling?
So I am seeing clients I was about to say patients, Dr. Sapilian. I'm seeing clients on a daily basis, both, as I said, remotely and in the office with masks, of course. Regarding the costs, everybody asks how much is an estate plan? Well, it depends on your family circumstance. It depends on how much specialized language we have to draft for your trust. Also, how many real property assets are we dealing with? Because we have to prepare a deed for each one. First, research the deed, prepare the deed and all the exhibits and the preliminary change of ownership report and any parent-child exclusion so that we don't have reassessments. Do you have children or not? Are you married or not? So these are all things that would change the pricing. I try to do a flat fee pricing so everybody's comfortable, but you know, every firm is different. I've seen estate plans go from as little as in the hundreds. You can take a guess at the quality of it. And then I've seen them in the tens of thousands, and you can understand some of them oversell, some of them don't provide enough. So it just find an attorney who's licensed in California and has been practicing in this area of law for a little while. As you know, any attorney can do anyone can draft documents. You can even buy software online, or I saw Costco even selling will maker software. Be my guest. But I love handling the cases that create those documents. Then the person passes away, and then we have to go through probate, and I can make 10 times the amount of fees as they would have paid for just a simple estate plan. Just giving you an idea. Not to scare you, but it really depends on the family's circumstance and the assets involved. And those are, you know, we can talk all day about that. The easiest is to contact me. I usually send out a client questionnaire, which is about 19 pages long. It asks all kinds of questions that we need to prepare the estate plan. And some people, in rare circumstances, I've prepared it the same day and rushed to the hospital and signed it. So anything's possible. It just depends on the circumstance. House calls, I'll do it for, you know, the elderly who are, or anybody who has a mobility issue. I'm happy to do that. But I prefer to do it in my office because last minute, there's always some kind of a change. And when I'm out of the office, I can't change the documents. We'd have to do it in the office. And it's just easier to do it with my staff over there. And also when we're signing the wills, I have my witnesses with me, the disinterested witnesses who are supposed to sign the will. So it just makes easier to make things go that way. But thank you for that question.
Gerard, can I ask you a question too?
Of course.
If let's say we've got a potential client who's got a practice, you know, a doctor or specialist, and he was booming and expanding and signing leases in multiple locations. And now, you know, things have gotten pretty bad in his specific practice. And so he wants to walk away from one of those leases. And he's got a personal guarantee, maybe a 1-year rent, a rolling guarantee of a year's worth of rent. If he comes to you to do his estate planning, is that going to help him get out of that personal guarantee by any way? Like, do you shift his cash accounts to a trust and then the landlord can't really touch him, or does that really help at all?
It's a great question. I get a lot of calls like this because first, let me explain that what we do is we try to keep things. When I do an estate plan, which is the standard estate plan, you're not changing things you're not losing control of assets. Meaning, if you are on title on something, you will remain on title, but it'll be in your revocable trust, which is disregarded for all intents and purposes because you can cancel it or amend it. Therefore, everybody disregards it. And if need be, you can pull it out of that trust. So it's not an irreversible transfer. Second, if we find out that somebody's doing some kind of a thing, knowing there's a creditor issue and they're trying to avoid that, we know that these transactions will get reversed with as part of a fraud claim. They would reverse those transactions and give the creditor the ability to grab the assets that the person was trying to hide from them. Lastly, a lot of clients come in wanting to put all their assets into an irrevocable trust for this specific reason, to get away from creditors. Well, that usually is done by people who have a very large estate, and they can put in assets that are throwing off income and give it to other people. So you would not put your primary residence into an irrevocable trust for two reasons. One, most likely you have a loan in there. And if you do that, your loan would become due and payable immediately because the ownership changed. Because remember, when you put it into an irrevocable trust, it's as if you're giving it to somebody else, not as if you are giving it to somebody else, and that somebody else is the beneficiary of that trust. And for it to be truly bulletproof, you have to give up control of the asset. So to achieve what you want, you have to give up control, put it into an irrevocable trust, but then the loan becomes due. You have to pay it off or refinance it under the trust. Now it becomes a more expensive loan because it's not a primary residence. It's now deemed an investment property. Another thing, you lose control of the asset, and that's a real loss of control where you can't just haphazardly, it's not your piggy bank, you can't take money out of it because the beneficiaries may have a claim against you. Yeah, I understand it's mother, father, and children most likely, but sometimes children turn on their parents, and we've seen that, and we've heard of that. So that's another issue to deal with. And third, let's say something catastrophic happens and you need to access cash from your home or get a home equity line of credit to do something else. You are locked out of that scenario as well. This is a great question you asked, Vic. I often get asked this question, and I turn away people because they have the wrong intentions on why they're doing the transfer, or sometimes it's for good intention, but the effects of it are not palatable for the people. They can't pay off that loan, or they don't want to refi into a more expensive loan, etc. Or most of the time, they don't want to give up control, and they don't understand that until I explain that scenario.
Okay. Those are great points. And I'd like to just point out that, we have a lot of viewers that are watching on Facebook, and some of them have joined as the Q&A session has started. If anybody watching on Facebook has any questions to our panelists, Vic Abajian, who is a tax attorney, and Mr. Gerard Kassabian, who's an estate planning attorney. You have the option of asking your questions. Please put them in the comment section. We are monitoring your comments. We'll ask those questions live to our expert panelists and try to get those answers to you. We have another, yes, go ahead, Gerard.
I have a question for Vic, because he brought something up that was very interesting that relates to all of our nonprofits. Regarding that nonprofit and the disaster relief loans, can you get into that a little bit more, Vic? I mean, nonprofits don't pay income tax anyway, but you were mentioning something about that. If you can elaborate a little bit. You said about the nonprofits receiving the disaster relief loans, or PPP. I forget which one it was that you talked about earlier.
Yeah, I think, well, nonprofits is a real, the taxation of tax exempt entities is a real subspecialty. So there's a couple of attorneys in LA that handle it, but we generally don't go there unless, you know, it's a live audit of we've dealt with some captive insurance companies that were tax exempt, but I'm not sure. I just know what I've seen reviewing PPP loan apps and an EIDL questionnaire that was on the SBA's website. So I think they did qualify for one or the other. It was probably the EIDL.
Yes. Probably
so,
both.
Maybe both, yeah, because a nonprofits, I mean, they range in all sizes and shapes, but they generally will have, you know, payroll, and they'll have employees and a director, and even, you know, certain families will have their own nonprofit charitable organizations that they set up within the families, and they've got certain, you know, they've got financials too, so they might qualify. I don't know about a PPP for a small family held one, but an EIDL, it's worth referencing. I'll check it out and see what I can find out.
Great, thank you. We have another question, which Gerard, I believe this is for you. And the question goes, have there been any significant changes in the law in the last 5 years that would require changes or an update in the living trust, durable power of attorney, and advanced healthcare directive? What circumstances dictate a review and an update if there already is a plan in place?
This is our friend Vahe Masarlian, who's a member of the Armenian Bar Association. Thank you for the question. There are changes that have come into effect. One of them that I'd like to mention, as of 2018, assets that avoid probate will also avoid Medi-Cal recovery. This is a huge issue that many of our people need to understand and get their estate plans in order. What am I talking about? If I received benefits from Medi-Cal, which is Medicaid in other states, meaning it's not Medicare for over 65, it's for about people who are low income or have made themselves low income to be receiving assets when they're later in age. If your assets transfer through a joint tenancy beneficiary designation or a trust, meaning avoiding probate, then the Medi-Cal or Medicaid does not initiate a recovery against you. That's something that everybody needs to think about. If their family members are receiving Medi-Cal benefits and they own property, that will be subject to recovery if they do not have an estate plan that contains a trust. Second, one of the major changes was the portability of the exemption amount. This was a huge deal back when exemption amounts were small. I'm talking in just a couple of decades ago, our exemptions were at 600,000, and then they started growing slowly. Now with the 11.5 million exemption per person, so for a married couple, a little over 23 million, most of our clientele, they're not at risk of being taxed and so they don't really use those um, techniques to reduce the estate size and whatnot. But if the exemption amounts get lowered, for example, administration changes, and then the current rules in place have a 2025 sunset provision, which means if they're not extended by anybody, they will automatically lapse. So in 2025, let's say the rule changes and it goes back down to 5 million, and your estate you're a married couple and your estate is over 10 million, and your spouse passes away and you haven't done anything to your estate plan to allow you to have the portability of her exemption amount, what you'd have to do is use that exemption amount and put her half of the estate into the decedent's trust that would be separate and apart from your trust. It would make things a little bit more cumbersome, but you would have to use that exemption amount at that time or lose it. Use it or lose it, as they say. The portability rules allowed us to elect to make that exemption amount from the deceased spouse be added on to the surviving spouse to be used whenever they want. So that's one reason why you would want to have your estate plan reviewed. Any estate plan that's over, let's say, 3 or 4 years old should be reviewed. And most of the ones that were done prior to 2015 have clauses, different clauses, such as back about 10 years ago, the thought was if you had children, you would leave assets, and they would say at age 25, I want them to receive 1/3. At age 30, I want them to receive 1/3. And at age 35, 1/3. Now they've changed the way they draft trusts. They now leave it up to the trustee, because at age 25, maybe they're not ready to take something, or maybe they're ready to take the entire thing at 25 because they're already professionals ready to go. Or they're in some kind of trouble and the trustee is required to transfer at age 25, and then creditors get the money, for example. All kinds of scenarios that you can imagine would be harmful in a scenario where a trustee is required to distribute 1/3 of the estate to the beneficiary. Now what they do is give the trustee full discretion on how, when, and how much to transfer. So these are things that, they're minor things when you look at it right now, but could be a huge thing later on if you think about the ramifications. Thank you for that question, Bai.
Yes, of course. I mean, that truly is would make sense as laws change from time to time and circumstances change from time to time. And, that is something that indeed should be reviewed. It looks like we still have quite a bit of Facebook viewership, and I'd like to again, as mentioned, if there are any questions from the Facebook viewers, you may please feel free to do so in the comment section, and we will address them. And while we are waiting for any final questions, truly, I'd like to thank, both of our speakers today for outstanding presentations. Mr. Vic Abajian on the nuances on taxation as it pertains to professional practice, including medical practice, and Mr. Gerard Kassabian on estate planning issues. Indeed, it has been a very interesting year, I suppose. We were having this conversation a few days ago on some of the challenges and intricacies of what this year has brought. And a point that was made was that in any type of adversity, there is opportunities. And these types of gatherings and these types of platforms have enabled us to connect in ways that we haven't been able to do before, or perhaps we have tried, however, with varying degree of success. So essentially, I'm thankful for the opportunities to work with our colleagues, with our sibling organizations in the legal fields. And as we all have to prepare for real life circumstances, typically our membership is healthcare professionals, many of whom are on the front lines. And as we all know, California appears to be one of the hardest hit states as of late. Los Angeles County having set a record for single day new infected cases as of yesterday, prompting a whole new wave of closures and rollbacks in the opening up. So essentially these types of gatherings, these types of exchange of information and knowledge, not just based on healthcare, as well as logistic issues and practical issues that will impact all of us as practitioners to safeguard our ability to care for patients, and safeguard our ability to also care for our families, our loved ones, and of course, ourselves. This is very, very important that we engage in these types of discussions and not just have tunnel vision on simply the healthcare or medical aspects of this global pandemic that we have all found ourselves in. With that, Gerard, I would like to invite you to have the closing remarks of this session. I thank you and the Armenian Bar Association for working diligently to organize these types of events to the betterment and the benefit of the entire community. And I look forward for us continuing in organizing these types of events in the near future.
Thank you very much, Dr. Kassabian. And to the two Vicans, thank you for being on with us. This is a treat to have two Vicans on. You know, our organization recently lost our chairman emeritus, Vican Simonian. So he's here in spirit. We have three Vicans here. Armenian Bar Association, we can find our slides as well on armenianbar.org. I welcome all the viewers who would like to be members. It's free membership for students, for pre-law students, and for first-year law attorneys. And we have postponed our annual meeting to the beginning of September, and we will post more information about that on our Facebook and website pages. And lastly, I wanted to again thank Vic Abajian, who's my mentor through law school, and he's now with me shoulder to shoulder on this Zoom platform. We're grateful to have you as an expert in the income tax arena with all of your experience and your practice that's doing very well. We're very proud of you, and we wish you continued success, Vican. Congratulations. And with that, we'll wrap up tonight. Thank you, and till the next Zoom event.
So
let's take a photo now, right, Vic?
Right. So I'm gonna ask all of us to look at the camera and approach and give a big smile, perhaps a thumbs up, or and as we're closing our event, I would like to just remind everybody that we'll be continuing these sessions. Please stay tuned and look out for announcements, and we'll look forward to seeing you soon. Please heed the advice that are coming from our public health professionals. Physical distancing, wearing masks are actually proven scientific advice. Please do so, just for the sake of our entire society. We all have individual responsibilities in mitigating the spread of this disease. Responsibility number one is to make sure that we don't get infected. Responsibility number two, to make sure that we don't infect. So let's all work together and get through this. We're going to get through this. We're going to come out stronger on the other side. So please be safe. Take care of your loved ones. Take care of yourselves. Have a lovely evening.
Thank you.
Thanks, guys.